All right, welcome back everyone to another We and Law Explainer. Today, we have a truly fascinating and honestly a highly relatable subject to unpack for you. Whether you're navigating the complexities of co-parenting yourself right now, or you just want a better understanding of how family law actually handles major financial disagreements, you are in exactly the right place. Before we jump into dissecting this crucial legal precedent, just a quick reminder to hit that subscribe button and make sure the notification bell is turned on so you never miss out on our in-depth civic education explainers.
Okay, let's dive right into this, because this question sits at the absolute center of a high-stakes, emotional, and financial dilemma that separated parents face all over the world. Imagine this scenario for a second. Your child is enrolled in a good school, you've got a solid financial plan that works for you, and then, suddenly, with zero warning, your ex-partner moves your child to a completely different, much more expensive institution. And then, well, they just hand you the bill. Are you legally obligated to pay it? Can one parent make that kind of monumental choice entirely on their own? You know, the answers here are deeply rooted in the law, and they might actually surprise you.
Section 1. The Co-Parenting Money Problem.
Section 2. The story of the transfer. So, let's ground this in a real story to see how this builds our understanding of a very universal conflict, sharing child-rearing costs after a relationship ends. When a separation happens, paying school fees almost always leads to serious disagreements. Today, we're looking squarely at a specific landmark High Court judgment, Family Appeal E087 of 2024, known as SMG v. EKA. At the heart of this case is a family whose marriage officially broke down back in November of 2018. The daughter was just finishing primary school, prepping for her exams. She did exceptionally well, which led to her admission into Kenya High School, a very reputable institution. Following her secondary education, she successfully transitioned to university. Initially, she enrolled at the Jomo Kenyatta University of Agriculture and Technology, widely known as JQAUT. This is a public university, and that detail is absolutely crucial for our timeline because public universities generally have predictable, stable, and relatively affordable fee structures. At this point, everything seemed to be on a clear, agreed-upon path.
But then, the inciting incident happens. Without telling or consulting the father at all, the mother makes a massive move. She decides to transfer their daughter completely out of the public university, JKUAT, and enroll her into Kabarak University, which is a private institution. There was no family meeting, no quick text message, no phone call, no mutual agreement whatsoever. This secret transfer is the exact catalyst that triggered the massive central legal battle we're exploring today.
Section 3. The Public versus Private Bill. Now, what's really interesting here is the severe financial consequence of that secret transfer. The words private institution usually carry a very different price tag than public institution, and the actual math reveals exactly why the father was forced to take legal action. Over at JQAT, the public university where the daughter was initially enrolled, the first trimester fee was about 108,064 Kenyan shillings, dropping just a bit to around 104,323 shillings for the subsequent trimesters. Right? That's a predictable, manageable financial burden. But over at Kabarak, the private university she was secretly transferred to, the school fees and related costs jumped significantly. The new bill came out to a flat, steep rate of about 150,000 Kenyan shillings per trimester. So we're looking at a massive, sudden increase in the cost of education, decided entirely by one person.
150,000 Kenyan shillings every single trimester. I mean, imagine the absolute sticker shock of receiving that bill when you were budgeting for something entirely different. When a legal battle inevitably fired up over who should actually foot these growing bills, the lower court made a really surprising initial ruling. They actually ordered the father to pay this entire amount, literally all of it. They ordered him to cover all the college fees at this private university, as well as her medical cover, despite the fact that he was completely left out of the decision-making process. Honestly, it's exactly like secretly upgrading your kid to first class on a flight and then just mailing your ex the premium bill. So, understandably unhappy with basically being treated like a blank check for an expensive school he never once agreed to, the father rightly took the matter up to the High Court on appeal to fight this unapproved financial burden. Let's follow his appeal directly into the halls of the High Court to see how the law actually interprets this kind of parental overreach.
Section 4. What equal responsibility means.
When cases like this reach the High Court, judges aren't just looking at the receipts, They look at fundamental rights. The Constitution clearly states that both the mother and the father share an equal duty to raise and provide for their children. That is, equal parental responsibility. So the crucial point here is that having an equal duty absolutely requires reasonable action and, most importantly, mutual consultation. You have to talk to each other. It means you're a team, even if you are no longer a couple.
And the judge provided a massive clarification here, and it's a quote you really should remember. Equal responsibility does not mean a strict, automatic 50-50 split of money. This is a huge revelation for a lot of separated parents. Mathematical equality goes straight out the window when one parent begins to act unreasonably. The law recognizes that a rigid, right-down-the-middle financial split is fundamentally unfair if one party is just driving up the costs without the other's consent.
So let's break down this rule of reasonableness. The judge emphasized that a parent cannot just wake up one morning, make a one-sided, unilateral choice to move a child to a much costlier school, and then expect the other parent to just automatically pay those heavy bills. You can't upgrade a child's lifestyle in secret and simply force the expense on your ex. When a parent does this, the extra money required is viewed by the court as a consequence of their own personal choice, not a mandatory, shared family expense.
Section 5. The High Court Verdict. All right, the stage was set for a pretty dramatic reversal. The High Court delivered a highly structured ruling in 3 specific parts that completely overturned the lower court's incredibly harsh order against the father. First up, the tuition cap. The court ruled that the father's only required to pay for his child's university fees up to the amount it would have cost at the original public university, JKUAT. Second, the extra cost falls entirely on the mother. Any higher tuition or boarding costs charged by the private university that go beyond that public rate, those must be paid 100% by the mother. Why? Because she made the solo decision. And finally, using state loans. The court noted that the adult child should take advantage of state student loan boards to lighten the financial load, and any aid received will actually be deducted from the father's capped requirement.
And this brilliantly illustrates the court's core philosophy on fairness. They firmly divided the financial liability based strictly on who made the choice. The father's obligation is safely capped at the original agreed-upon public university fees. He's protected. On the other side, the mother's obligation means she bears all of the premium extra costs caused by her solo decision. The court effectively separated the shared necessity of education from the personal luxury of a private, unconsulted upgrade. Section 6. The Golden Rule for Parents.
Because really, this case is about way more than just a specific tuition bill in Kenya. It provides a massive, overarching civic education lesson for all separated parents. Fairness, teamwork, and clear communication are mandatory in the eyes of the law. They're not optional. This judgment sends a powerful message. While wanting the best possible education for your child is obviously a noble goal, the law requires parents to actually talk and agree before making major financial leaps. Providing for a child's future is vital, absolutely, but so is maintaining fairness between the co-parents.
So I want to leave you with this somewhat provocative thought. How will you communicate your next big co-parenting financial decision? Because as we've clearly seen today, keeping secrets can become a very, very expensive mistake. Thank you so much for joining me for this comprehensive explainer of the SMG VEK ruling. If you found this breakdown valuable, please confidently tap that subscribe button for We in Law. Hit the notification icon and join us next time as we continue to make the law clear, accessible, and understandable for everyone. Until next time, take care.